Good afternoon, everybody, and thanks for joining us for another program in Con Maciel Carey's OSHA webinar series, the 2025 edition. And I'm really excited about the program today. This is one of these things, many of you have been following this program for years. We've been doing this for a decade at the firm, where we sit around in late fall, early winter, and try to come up with topics that we hope and expect will be timely the next year, and that we think will be interesting and valuable to our clients and friends of the firm. And we really nailed this one. The idea that we came up with this topic for a June program more than 6 months ago, with everything that is going on right now in terms of what letters of interpretation are, how they can be used, whether they're supposed to be deferred to in any special way, and in particular, the reason they're timely today is that this administration has opened the door and invited opportunities to revisit old interpretations and seek new interpretations in a way that we've really never seen an executive branch call for from stakeholders before. And so it's really timely opportunity to talk about some really interesting stuff. So let's real briefly introduce ourselves and get into this heady and interesting discussion. I'm Eric Kahn. I think I know most of the folks. I saw most of the names. We're familiar friends and friends of the firm and friends of our webinar series. But those that don't know me, I'm one of the founding partners at Con Maciel Carey, and I chair the firm's national OSHA Workplace Safety Practice Group. I've practiced exclusively in the field of workplace safety and health law for, for 25 years, which is scary to say out loud. A little more than the first decade of that practice was alongside the first general counsel of the OSH Review Commission. Moved on to another firm and eventually launched Con Maciel Carey a little more than 10 years ago. So it's exciting. We're still in our celebrating our 10 years anniversary. So it's been a special time. Let me pass it over to my senior partner, Kate McMahon, to introduce herself.
Is it like senior status where I get some time off every now and then? Good afternoon, everyone. It's great to be part of this continuing series that we put on. I hope it's going to be an interesting one for y'all today. Many of you know me. I have practiced in this field for somewhere over 30 years, but actually started out as an environmental lawyer. And as I tell so many of my friends and colleagues, boy, I tell you, when I had the opportunity to sort of transition my practice to occupational safety and health from environment, it was a very good day. I love this area. I feel like the work that we do helps our clients, our employer clients, as well as their employees. I was telling OSHA just earlier today that we see our clients as our employer and their partners, their teammates, their employees, and our goal is to represent you and make sure your folks stay safe and healthy. And we know that's your goal too. So that's our joy. That's my joy, and I'm glad to have the opportunity to talk to y'all today. So Scott, our newest member of our team, why don't you introduce yourself?
Sure. I'm Scott Hecker. For those of you who I haven't had the opportunity to meet yet, happy to be here to chat through these issues with Kate and Eric. I have been practicing workplace safety, either MSHA or OSHA, for I think about 17 of my 20 or so years in practice. And I spent over 10 of those years with the Department of Labor in the solicitor's office. Initially as a trial attorney, so out in the field, and then in the national office in the Occupational Safety and Health Division. So OSHA was my sole client during that period. It was about, 2015 to 2020, so about 5 years where OSHA was my sole client, and I was focused on occupational safety and health issues. So somewhat know how the sausage is made and can speak to some of the internal processes. but also have experience in a number of law firms, including my most recent stop before Con Maciel was an international law firm where I did focus on a lot of the substantive areas that the Department of Labor continues to administer. So remain familiar with occupational safety and health and MSHA and other areas as well.
Excellent. So, in all seriousness, the topic today is pretty heady stuff. It's we're going to invoke Chevron deference and the change in that legal landscape from Loper Bright. We're going to talk about guidance versus standards from some other big time cases out of the DC Circuit and the Supreme Court. And we find this to be, as speaking only for myself, a giant regulatory nerd. Really, a really interesting topic and an important topic for what we do, maybe more what we do as your lawyers necessarily than what you're doing implementing safety and health programs, but it certainly affects what is considered compliant and not compliant. So it's really important. We're going to do this discussion today because it is, I think, a little bit loftier thinking than a lot of what we cover in other programs, a little bit more like a panel discussion. We've got our slides, and there's going to be some good content in there for everybody to take away, and it will be a little bit of a roadmap for us. But I'm going to ask Kate and Scott to keep your cameras on and keep your microphone open, and let's all just weigh in as we move through the discussion today. And we're going to sort of talk about what is a letter of interpretation, where do they come from, how do you get one, how are they used by employers? How are they used by OSHA? And then talk a little bit about the shifting legal landscape from some of those big cases. And then at the end, we'll talk about this sort of unique window of time we're in right now, where there may be a pretty receptive audience in the current administration to issuing new, maybe employer-friendly interpretations, and how we might collectively think about pursuing those and what subjects and topics might be useful in that regard. So I think the very first question of the day is, what is a letter of interpretation? That's the subject of our webinar. What is it? And I think start with Kate on that one.
Sure. Well, let me say a couple of things, not only about what they are, but where they are. Let me start with the easy part, where they are. This is my colleagues on this webinar will recognize that I'm not the most advanced when it comes to technology, but even I can find the letters of interpretation on OSHA's website, right? So you go to OSHA's website, there's a drop-down menu, you pick standards, there's a drop-down menu, and one of them says interpretations. You click on that, and there is this world of LOIs that we're going to talk about today. And there are, gosh, I didn't count. I don't know if you can count, but hundreds and hundreds and hundreds, if not thousands. One of the things we need to mention before we get off the phone today is what the difference is between an active LOI and an archived LOI. So we'll talk about that. But to give you a sense for those of you who aren't familiar with letters of interpretation, they are essentially what we say here. They're publicly available. The way I just described, you get them. Interpretations, official interpretations of the agency of a particular regulation. So you all know when a regulation typically at OSHA takes about 10 years to promulgate, right? From start to finish. That's probably quick for many. But let's say it takes 10 years. What you end up with is a regulation in the Code of Federal Regulations that is about 7 pages. And there is years of work and thousands of hours of thought that have gone into these 7 pages of the regulation or the standard. Where is all that background? Well, part of it is in the preamble that's hundreds of pages that leads up to this standard or regulation. But even with the preamble, there are a lot of remaining gray areas. There'll be a sentence in a provision, and it won't be clear what it means. Letters of interpretation are efforts by the agency requested by non-agency stakeholders, i.e. employers or employees or labor unions or whatnot, to the agency to say, here's what provision X in the Beryllium Standard says. What does that mean? Or does it mean X or can it mean Y? And that question that is posed to the agency is answered by the agency in an official letter that the stakeholder who asked the question receives. And then that letter is posted on OSHA's website.
Yeah, I think it's important to remember that, and I think we have this at the bottom there. These aren't meant to they're not meant to be rules, and we'll talk more about this. I don't want to get too far ahead because I know we will talk about what they are not, but they're not meant to create additional rights and obligations. They're meant to be letters of interpretation, right, of the existing law. And to your point, Kate, about archive versus active, they are interpretations of current regs and current law. So if there's a rulemaking that withdraws something, you might have to archive letters of interpretation that deal with that reg. It doesn't exist anymore. Or if there's a modification to a reg, you might have to update an LOI, or an employer might want to ask for an updated LOI. But they also deal, I think, narrowly with the specific circumstances asked about. And while they're available to make arguments through litigation, again, we'll talk more about this, but you have to understand that they are meant to be specific to the requested circumstances. And I think when SOL, the solicitor's office, was involved, or if I was involved in sub-regulatory guidance of any kind, we were cognizant of not overstating the existing law. You don't want to do that. That's what the lawyers are supposed to backstop, right? And then also making sure the application was narrow and that we weren't saying this is true for every circumstance that's covered by Lotto. It's a very specific question for lockout, tagout, in whatever, as you said, Kate, a particular subdivision or sentence of a subdivision.
Essentially applying the law to a set of facts and giving
Yep.
the answer.
Exactly right.
Okay.
Yeah, and that's why you'll see in many of these letters of interpretation, they'll start off with a sort of restatement of the facts, a summary of the factual circumstances that were presented by the request, then a specific question about how the standard applies to those facts in some way, and then the agency's interpretation is, hopefully the bulk of the letter, but it tries to answer that question. And they'll often reference other letters of interpretation that have been issued in the past. They'll put, very often you'll see direct quotes from regulatory text or from preambles or things like that, basically saying, here's how we interpret the application of the standard to the set of facts you asked about, and maybe a little bit of support for why we think that is the proper interpretation and the agency's official position as to what that standard means.
And sometimes, one more thought, sometimes they duck,
Yeah.
right? Sometimes they duck the question, and what you get back is a non-answer. And we can talk a little bit more about that too when we talk about strategy.
Yeah.
Well, and Kate, if you go to their website, they actually say, OSHA says, and you can go to the next slide, actually, Eric, this is a fine segue to the next slide. They say they have discretion about which ones to answer as well. So they can fully duck it.
True enough. Good
yeah,
point.
if you request one and they say, I don't think so.
Yeah, you actually see at the top of every one of these this, very aggressive disclaimer, like you might see like on my Twitter page, that these are just my opinions.
Yeah.
We're not speaking for, we're not creating law. This is
Right,
not creating
exactly.
law. It is purely interpretive. But it, at least historically, has had a pretty meaningful impact on what the law is. And we'll get into that as well. But let's figure out a little bit about.
Also, historically, Eric, they thank you for your interest in occupational safety and health at the end.
Well, the other thing I was going to say is that almost 100% of them, what do they start with? An apology for how long it's taken us to get back to you.
Well, good point. Good point. The
So-
timing is an issue, right?
Right.
Yeah.
So the standards take a long time to write, but getting an interpretation letter out of the agency takes a long time too. And part of the reason why is the
You're
layers
going
of bureaucracy that I think you're going to talk about right now, Scott.
Yeah, you can go through multiple levels of review and actually coordination among different agencies, really. OSHA has different directorates, standards and guidance, enforcement, and then the solicitor's office is really a separate obviously office or division under the Department of Labor's umbrella. So again, lawyers are, we had a colleague recently say word people. And so once you even get to the point where, there may be a draft letter of interpretation, or even just you reviewing the request, you really have to think about that response and how it's going to provide the interpretation, as Kate put it in that succinct sentence. How does the law apply to this set of facts, without overstating it? And of course, the Directorate of Standards and Guidance deals with standards and guidance, as the name suggests. And obviously, letters of interpretation are very important to that group. They don't want to put out guidance that's inaccurate. They don't want to, put out guidance that is improper. The Director of Enforcement, as we said, these may be used in enforcement actions, including litigation. So the Director of Enforcement wants to be sure that what's out there, I'm sure they want to be sure what's out there is helpful to them and their enforcement practices, but we, also want to have an even-handed, hopefully, interpretation out there. And that's where the solicitor's office as well is involved, to make sure the statement is appropriate under the OSHA Act, existing standards and regs, so that we're, again, not changing law through these efforts. And it's something that should not, asking as an employer, can I do this, shouldn't. This is a compliance assistance goal, and I think the agency wants to encourage that. Particularly, you often see a pendulum shift towards compliance assistance under Republican administrations. So this isn't, I don't think, a trap, but nonetheless, we'll talk about how you should be wary and circumspect when you are requesting these. You don't want to put something out there that is then, going to, even in the back of OSHA's mind, cause them to say, you know what, we should look at that person who just asked about this thing. Now, they shouldn't do that, but I'm not saying, we're all human, right? So it is something to be careful through this process. And, we'll talk more about this, but to involve, I don't know, a competent counsel like Con Maciel, to guide you. So.
Yeah, so there actually was a great question came in the chat directly on that point. Yeah, we're looking at the screen right here. The Directorate of Enforcement is involved in the LOI process. If I send in a letter and I say, I'm company ABC, and we've set up our machinery like this, and if we set up our machinery like this, is that compliant? And if the answer is no, how likely is company ABC Inc. to see a visit from OSHA, an enforcement inspection? Because now OSHA knows how they've set up their equipment and OSHA believes it's non-compliant. Are they going to get inspected for that? And
I'd consider fixing it promptly, Eric, if that is OSHA's stated enforcement position.
yes, for sure.
Well, I would consider not sending the letter in before you know the answer, even before that. But yes,
And I think that's where we're going next. And I think that's exactly this. I mean, there's two things there. One is,
Mhm.
let's find out what the answer is before we submit the request. The other is, let's have somebody else make the request, right? There's no reason to identify your organization in this request when you could have counsel or a consultant or even just write the letter as a citizen without identifying your organization. I think to Scott's point, they're really not supposed to be this sort of retaliation or they're not using this as a data point for their enforcement targeting. But if it was a big enough issue and they had some other excuse to do it and they knew a company was doing something the wrong way, let's put it this way. I think it would be enough to get a warrant. And so if they wanted to do that inspection, they would have their administrative probable cause because you communicated to the agency that you have a hazard at your workplace or a condition or a work practice that the agency has determined is unlawful. That would be treated as an admission that would be at least sufficient to get a warrant. So I think there's a lot of reasons from a strategic standpoint for how to handle this a little bit differently than just sending in a letter cold under your own company's name. And why don't we have Kate, who I think is a master of this process, to talk about this process a little bit.
Sure. And let me just say before just for those of you who aren't familiar with the LOI process, Eric made a comment a minute ago about, or I think our point is, it might not be best for you, the individual company, to send the letter in, even if you've vetted it before, right? Just to be safe. If you're going to be describing something that is potentially non-compliant. But in addition to council, trade associations sometimes can send in a letter without identifying any particular company. And if it's generic enough, OSHA's not going to entertain a industry-wide inspection and wouldn't get a warrant for that. So that's one way to do it in addition to council. But also, FYI, these letters of interpretation apply. Whoever sends them in, they apply broadly. That's why they're on OSHA's website, right? Unlike a variance, where a particular company will apply for a variance from a particular rule, that applies to only the variant, the person who has received, if you are the rare occasion, a rare requester who receives a variance. But if you get one, that applies to you and you only. For LOIs, they apply to the entire public. All right, strategy. We feel very strongly that, it's sort of like what you hear about cross-examination. Don't ask a question that you don't know the answer to. Eric has some horror stories about folks who have actually just feel very confident in their interpretation of a particular provision in a regulation, and so sends OSHA a letter saying, hey, this is what we're doing. We're unjamming this equipment. Is that a minor surfacing activity under MSE of the Lotto standard? And if the answer is no, you've really, as Scott said earlier, I mean, you better pretty pronto change that practice. You now have the agency officially saying that is non-compliant. We'll talk about the consequences of that, but the obvious consequence is, I mean, setting aside whether you get an inspection or not, the obvious consequence is if you are inspected down the road and you're still doing this, is that willful? You already know that you're not supposed to, and you're still doing it. So there's some real negative consequences. But the way to avoid all this is to be strategic about getting these interpretations. There is more gray area than not in every regulation that OSHA has ever issued, including, I think, the only standard that has been issued in my, maybe not lifetime, but my practice time, that did not have a significant litigation challenge, right? So that one survived essentially without litigation challenge. It's still filled with gray area. So you're going to need, employers need to understand what is allowed and what is not allowed by a particular provision in a standard. So what we do, we've developed this process that really works. It works for all sides, I think, for employees, it works for OSHA, it works for us, employers. And that is, we figure out what we think the answer is based on not just the words in the regulation, but the preamble and other guidance. We do the legwork associated with a particular provision. One example that I have is whether you can use disposable bags under OSHA's beryllium standard, whether your PPE washing requirements allow that require in the standard impermeable bags, whether you can use these disposable laundry bags. So I'm using this as an example to show that there's a lot of information under other OSHA standards about what impermeable means, how you have to protect the person that's coming to pick up the laundry, how you need to make sure that those toxic materials in the hazardous PPE is kept confined to the laundry bag. So you do the research, you do the legwork, you figure out what you think the answer is that is consistent with what you want to do. In this case, for instance, use a disposable bag that meets all of the goals and objectives of OSHA, but is certainly not obvious in reading the PPE laundry provision of the beryllium standard. You then reach out to the agency And we usually start with standards because those are the experts, the subject matter experts on the standard. They wrote the rule, right? They know what it means. By the way, if the preamble's clear, that you got a big leg up, right? So you might not even need a LOI if the preamble actually speaks to the issue. So it's important to look carefully at the preamble. But if it doesn't, you go with your proposed interpretation of the standard to the standards and guidance folks. And you talk to them, you engage in discussion. You got to get to the right people. It's like calling up, Amazon or Apple and getting the right technical guy on the phone, right? It takes multiple reach outs to get the right person who's interpreting this particular, who was responsible for writing the PPE portion or the laundry portion of the beryllium standard. But you get that person and then you engage in discussion and you work through it with them. And ultimately, hopefully, with some, hopefully not too much prodding and persuasion, you reach a consensus agreement as to the standard allowing disposable bags as long as they do this, X, Y, and Z. Then they become essentially your advocate. They're now internal to the agency, the key stakeholder within the agency responsible for issuing these interpretations. And they then do the legwork internal to the agency with their partners, with both the Directorate of Enforcement folks and with the Solicitor's Office, ultimately, to get sign off from both of those entities so that you have this tripartite consensus agreement that is essentially what you put together and brought to standards. In fact, we recommend writing it out. Like, here's the interpretation request. You don't send it in. You don't ask for it. You make very clear you're not. This is a draft. This is what we're thinking, the way you guys think, the way we're interpreting your language. You pull in the preamble, you pull in other stuff, whatever. You explain it to the agency. And then once you get their buy-in, they then advocate with enforcement, make sure it's clear there, talk to the solicitors, make sure they have no problem with it. But you stay involved all along that process. You have not submitted your request until you get final sign-off from standards that this is the way the agency, the department, views this particular provision. And then you send your letter in and you essentially guarantee you know what the response is. Obviously, there could be some change that would be unexpected. I guess no guarantees till the, whatever. No guarantees till you have the letter in your hand. But, you have 97% certainty you know where that's going before you've ever submitted the letter.
And so, the flip side of that, and there's so many examples of this, if you just look through the catalog of interpretations, or worse, when you're researching something to try to counter a new citation that you think, well, that's clearly the wrong interpretation, then you find this terrible LOI out there, and you can tell these circumstances, and some that just we know from our experience and connections, that the letter was just sent in cold, without any engagement with the agency beforehand, and not even really advocating for a position at all. Just a very cryptic statement of some facts, leaving out some really important ones, and just leaving it to OSHA to say what they want to say. And one example that I remember, because it occupied multiple years of my life trying to undo the damage from this letter, there was an auditor, like a risk assessment auditor for an insurance company, that was watching a bunch of his clients in the grain industry sending employees into grain bins to sweep up behind these energized sweep augers that go around at about a half a mile per hour around a grain bin. Sometimes it takes a day or multiple days to make one pass around these giant storage bins. And the standard, uses some language about disengaging, ensuring that energy is controlled before employees enter bins. And he just wrote this letter, with basically no context and no background, saying, are they allowed to be in the bin with these energized sweep augers? Meanwhile, OSHA, the national office, has no idea what a sweep auger is, has no idea how these things work. and doesn't know, what standard practice is. And they just fired off a letter that said, well, unless you can guard, all sides of the auger, including the part that is intended to contact the grain and move it, then you can't do this work. And this basically crippled the grain industry, pretty important to our food supply in this country, because nobody could get, grain out of bins. They couldn't clean out the bins. They couldn't completely empty them. And it took a bunch of litigation, ultimately in a case that I worked on in the Midwest with a really, really knowledgeable OSHA area director that had grown up on a farm and understood what any of this technology was, that we negotiated a settlement that he got buy-in from the national office, but he became an advocate as well on this, where we created a new enforcement protocol that ultimately resulted in OSHA withdrawing the old interpretation and writing a new interpretation that just copied and pasted from this settlement agreement. But it took us probably about 5 years to get from that bad letter to the new letter. And it was a lot of chaos in a really important infrastructure industry in our country, where people were, in trying to invent all kinds of new technologies that weren't working, and in many instances were making the task less safe, and just a lot of chaos that could have been avoided by having a thoughtful discussion with OSHA about the situation before requesting the letter. By going in and explaining to them, this is what an auger is, this is how it works, here's how we do the job safely, here's literally the only way to be able to do this work. And that's what we ultimately did, and got the letter that was needed for the industry, but not until after a really bad situation, because that process was not followed. So, it's not trickery, and it's not, we're not trying to put words or thoughts in OSHA's mind, but we're advocating and we're explaining and we're providing additional context, because that's usually the problem here, is that cold letter that comes in out of nowhere doesn't provide enough context for the right outcome to be received, or to be obtained. We have the idea here at the end that, like, if you're not getting the answer you want, don't submit the request. That only gets you so far, because you still have knowledge now of how OSHA thinks the standard applies, but it's probably better to not have that bad answer in writing affiliated with your request. But that doesn't mean that the interpretation doesn't exist. I don't know if you have any thoughts about what happens in those situations where you just can't negotiate or advocate to the right result.
Well, I mean, I think that you make a really good point there, because if we engage with the agency and ultimately they have support for their position that is contrary to what we think should be the way this reg is interpreted, it's important to understand that. So you don't get your cake at the end of the process. But you get an understanding before any enforcement action, before there's some letter out there that can be used against you. And you work, then in our case, we work with our client to help address the issue and make sure that what is happening is compliant. So it's a defensive process. I mean, these LOIs are shields and swords both, right? And we want to use them as shields. We want to avoid the sword. So
one thing, and I think Scott mentioned this a little bit in the discussion about what letters of interpretation are, it's important to understand what they're not and what they're really not supposed to be. They're not supposed to create law. They're not supposed to change law. They're not supposed to create new obligations. And there's been some really interesting litigation on this point. This was a pretty significant in the regulatory circles, not just for OSHA, even though it was an OSHA case, but pretty significant for all regulatory context. In 2016, the DC Circuit, that is thought to be uniquely sophisticated on regulatory issues, so these cases often end up in the DC Circuit, the U.S. Court of Appeals for the DC Circuit, the federal court, looked at a situation where OSHA had issued a letter of interpretation almost contemporaneous with a new standard being issued. And that interpretation letter being out there for industry to rely on for decades. And then OSHA deciding one day, I don't like that interpretation because the way it's written, there's an industry segment that's not covered by a standard that we think could have prevented a really bad accident. So let's just throw that interpretation letter in the trash and reinterpret this standard. And the DC Circuit looked at this and said, "Geez, if you're if you're writing an interpretation letter or rewriting an interpretation letter that imposes a whole bunch of new regulatory obligations on a whole bunch of employers who, before that interpretation letter, were not subject to those regulatory obligations, that kind of feels like it's a standard, not guidance. And if it's a standard, you can't just write a letter and that becomes the standard, right? To write a standard, as Kate talked about, you've got all that Administrative Procedure Act hoops you've got to jump through. That's the stuff that takes 10 to 12 years to issue a new standard. Well, writing a letter, that could be done overnight, and you've just skipped all that burden of that Administrative Procedure Act requirements. And in this case, Agricultural Retailers Association, it was a trade association on behalf of its members challenging a new interpretation that OSHA wrote in that context. There was basically a whole bunch of employers who sold their agricultural goods like fertilizer and other materials directly to a end user consumer, and they were not subject to coverage by the PSM standard. And it was called the 50% test. If more than 50% of your income comes from selling to an end user consumer, you're a retailer and can avail yourself of the retail exemption to the PSM standard. OSHA wrote a new letter after a terrible explosion at a fertilizer company and said, yeah, forget the old 50% rule. Now we're just going based on NAICS codes and a certain set of NAICS codes that are clearly retail oriented. That's how we define the entities subject to the retail exemption. Well, the DC Circuit looked at this and said, when an action by OSHA corrects a particular hazard as opposed to adjusting a procedure for detection or enforcement, it amounts to a standard. And the effect and object of this new letter of interpretation, redefining the retail exemption, expanded the substantive reach of the PSM standard by narrowing that exemption. And because this letter of interpretation subjects a substantial number of businesses previously classified as exempt to additional safety standards to address a particular risk, it qualifies as a standard within the meaning of the OSHA Act, and therefore OSHA was required to follow notice and comment procedures. So this letter of interpretation that OSHA wrote was really a new standard masquerading as a letter of interpretation, masquerading as guidance. And you can't change regulatory burdens on employers. You can't create new burdens on employers by way of guidance. And so there's this fine line that OSHA has to dance when it is issuing interpretive guidance to ensure that they're not actually creating new regulatory burdens on employers. And in this instance, it was the idea of changing a decades old interpretation that made it really feel so much more like they were creating new burdens. I think the agency probably has a little bit more discretion when they are interpreting a standard for the first time, but when they're reinterpreting something and reinterpreting in a way that it applies anew to employers or it creates new obligations, they're going to face a lot of scrutiny from the courts as to whether it was lawful to do this by interpretation at all. So I don't know if you all had any additional thoughts to share about that.
Well, it'll be interesting to see what we see over the next couple of years, because the flip side of the coin would be interpreting existing regulations in a way that is deregulatory in nature and lessens the burden on employers. And What will labor unions think about that? And will they challenge that legally? And so, it'll be interesting to see. And we're going to talk a little bit about a new process that that the Department of Labor just unveiled, that suggests that there may be some effort by the agency to use interpretation letters, LOIs, now called opinion letters, for this purpose.
Yeah, that's right.
And I just picking up on that, Eric, I think, and you can go to the next slide. This sort of segues into it, but I think, and we've had some questions in the chat about it, but the LOI itself is not something that gets enforced. It's an interpretation of existing law. So the reg would get enforced, the standard would get enforced, the OSHA Act General Duty Clause would get enforced. The letter of interpretation isn't something that's going to get enforced, but as Kate pointed out from the beginning, it's publicly available, and it's something that stakeholders can rely on and OSHA can rely on. If it has an opinion out there that says, here's how we interpret the standard, so clearly you know that, you had notice, we've satisfied due process, all those things, it can help OSHA in an enforcement action. Sorry, Kate, I know you appear to have something urgent to say, but OSHA can use that in enforcement action or litigation. Now to Kate.
Yeah, sorry about that. I will tell you, we are lawyers. We know to look for these LOIs. And I did explain that they're very easily findable by even non-high-tech people like me. But non-lawyers don't know, like, they know there are laws,
Yep.
statutes. They know there are regulations. Below that, there's sub-regulatory guidance. I think most regular old Americans are clueless that that exists, right? So there are folks in your facilities guaranteed that don't realize this body of law, of interpretation of the law, exists, that is used to define by the agency what this law means. So, to Scott's point about this is fair notice, due process. I don't know, query, is it? Right? It certainly has been interpreted to be that, for sure.
You're right. I mean, it's better than when OSHA either doesn't have it or, is trying to push an interpretation that doesn't align.
Absolutely.
And Eric and I had a recent case where we were successful and it wasn't an LOI, but it was memoranda on sort of an enforcement policy. And we were able to say, well, the clear face of this policy says, here's what it covers. And what you're citing us for is not on that. So we were able to use that kind of sub-reg guidance to our benefit. Now, OSHA will try and do the same. But again, I want to make clear, this is not supposed to be substantive law for all the reasons Eric just said. If they're making substantive law, if there's a big change that's really changing the fundamental requirement or obligation on an employer, then it should go through notice and comment. It shouldn't just be an interpretation that gets thrown out there to change what was decades of an existing policy. And that length of time, even post Loper Bright, I think the consistency of interpretation is still going to be something courts look at for the persuasive authority of some kinds of these kinds of guidance. But yeah, I mean, we have a slide up here, when and how to use these. And this is sort of, how OSHA might do it for a bunch of these, but they're looking to clarify how they apply. The agency's looking to clarify how it applies the act to that particular workplace or particular procedure that a stakeholder is asked about. They're trying to communicate their understanding as the agency, how they're going to look at it. And a lot of this is, to me, giving a heads up about an enforcement protocol and process. I mean, they're saying, if you're doing this a different way, we disagree, and we would find non-compliant this practice, or hey, it sounds like you're doing it right. And that can be helpful too, obviously, for anyone involved. I think when not to do it, and I don't think they deal with it, we talked about the discretion. If you have a specific issue in litigation, I don't think you're going to get around, whatever OSHA's arguing litigation by asking OSHA and the solicitor's office to go with your interpretation in an LOI. That's probably not going to be effective.
One interesting situation I had, Scott, was when I was in litigation with a state plan about a standard that was identical to the Fed standard. And I knew what Fed OSHA's interpretation of that standard was. There wasn't a letter on the books yet, but I knew how they applied it and had talked with a lot of folks in the solicitor's office and at OSHA about it. And I did in that one, this is like the narrowest circumstance where this would ever apply. I asked that state agency if we could stay the litigation while we pursued a letter of interpretation from federal OSHA on the subject that I thought they might find informative. And they agreed, which I was surprised they were willing to agree to do that. And we did it. We got the letter that we expected we would get and shared it with the state agency, and they agreed to amend or to amend one citation and vacate another based on seeing that interpretation. That is an extremely rare circumstance. You definitely are not going to do this during engagement with federal OSHA about seeking a federal
Right.
OSHA interpretation when you are disputing with federal OSHA. But that window did open once, so I thought I would share it because it was
Yeah, and that's interesting. I mean, the website that Kate referred to, where this stuff is all publicly available, says these letters apply to federal OSHA, and state plans may differ. So they do explicitly say that. Now, state plans have to be at least as effective, right? And so they may adopt.
Unless
I
you're in
mean,
Kentucky.
well, yeah, right, not anymore. But they're supposed to be, according to the OSHA Act, at least as effective as the OSHA Act. And so um, enforcement and the regs are supposed to be at least as effective. So the issue then becomes whether a state might adopt the same perspective, or, for example, our favorite outlier, California, has a number of different practices that are, probably above the federal floor of OSHA, right? So they may interpret their regs. They may not first have an identical reg, and then then of course you'd have a different reg, and that state agency would be interpreting its regs if it had a process, a similar process like this. So
Can we dig into that a little bit more?
yeah,
Because there is a great question in the chat about that is, how can these interpretations, how do they affect what's happening in the state plan states and perhaps vice versa? So I think to your point, when you've got a different regulation, right, slightly different, completely different,
yep.
then your Fed OSHA interpretations, I think, are not going to be particularly meaningful. But so many of the state plan regulations and standards are copy and paste, right?
Hmm.
Straight from a federal standard. And in that situation, my view is the states can offer a different interpretation, right? They're a separate agency. They've got their standard. They could interpret the standard differently. But to the extent they have not done that, right? And I very few states actually have a collection of interpretation letters like FedOSHA does. There are some, and there's very few. But to the extent they have not put out a public interpretation about a standard that is identical to a federal standard, how do you all assign value to the federal interpretation letters? What are they worth in those states?
If they're identical, I think I would argue, and you could actually find whatever the state equivalent to the Occupational Safety and Health Review Commission, the ALJs, the hearing officers, whomever, they'll say in the absence of guidance from us, we look to federal, right? You have a lot of the state plans that say that. I
Yep.
think one danger for the state, I think, if they were to argue, yeah, we know what OSHA says, but our interpretation is different. To me, I'd immediately be arguing that that
Fair
interpretation is
notice.
not as effective, and probably that there wasn't notice about it either. But I mean, I
Yeah.
think you get into the fight where is this as effective, because that's OSHA that says, blesses the state plan to say, hey, you are as effective, so we approve your state plan and you can run it, right? And so if that state then says, well, we think this interpretation is different, and then you're in a space where arguably who's making, I mean, a judge is making the determination that it's as effective as the federal standard, that seems pretty dicey for the state to pursue.
Mhm.
I'm in a litigation right now, nothing to do with an LOI, but two statutes have identical language, and we've got two agencies interpreting that same identical language very differently on a particular issue. And I think we've got a pretty powerful argument to make that these are sister agencies, and there's a whole bunch of stuff which I'll take up the rest of the time, so I won't go into, but I think, words mean something. Words are words, right? And lawyers
Yep.
know what words mean. And agencies should know what these words mean. And it's very hard, I think, to argue that these same words mean something different. Now, query the opposite situation where it's OSHA, they've adopted, let's say, the same exact language, but they're interpreting it more stringently. Scott's situation doesn't apply because, certainly it's as effective as.
Right.
More effective, right?
Actually more effective, but it still is there a notice argument. I relied on this language that was interpreted by federal agencies. So
to me, I think that fair notice argument, constitutional due process, fair notice, is what carries the day there. Like
Agree.
you state agency didn't say anything about what it means. Fed OSHA has interpreted the exact same standard regulatory text to mean this. That is what I am on notice of what is expected of me. You can't, through an individual enforcement action, just change that interpretation without giving me notice. I think that would be a pretty compelling argument for how Fed interpretations could be really useful in state plan litigation, assuming the standards are the same or very, very similar. Yeah.
And just think about federal as the floor in that circumstance, right? At least as effective. And as you both said, could be stricter, could be more effective, whatever that means. But
unless you're in Kentucky.
But
right, then you don't have to follow that
given,
anymore at all, right? The legislature was like, forget about the OSHA Act.
But the regulated community has to be given notice if you're doing something above the floor.
Greater. Yes, correct.
And so they could do that by writing their own standard that's more rigorous, or they could put out an interpretation that is more rigorous. But until they've done one of those two things, I think they're stuck with what the feds say.
I think we win that one. And speaking of notice, I don't know if this is the next slide or not, and we've already sort of raised this. Oh yeah, there we go. So, on the federal level, there's the general duty clause. And speaking of notice, well, it works both ways, sword and shield, right? So OSHA will say, hey guys, I interpreted this. It's on my website. You have notice that this particular, reaching into this machine to clean it or unjam it or whatnot is a violation of the lotto standard and a hazard, a recognized hazard, because I already told you, I didn't tell you, but I told the public in a letter that I issued and is on my website 7 years ago, that this is not compliant and a hazard is presented to this employee's hands. And I, now OSHA, use it as a sword to rely on it to say you had notice.
Right. And we note there both for willfulness or general duty, industry knowledge, all those things, OSHA could use it as that sword as opposed to where we could use it as a shield to say, hey, OSHA, you told me I was good on this. But yeah, it is a two-way street here. And that's, again, I think goes back to exercising caution and being wary when you are developing these things and deciding what and whether to ask.
We only get the ones written that are shields, by the way.
Yes, correct. Yes.
FYI.
There's they can't possibly, they never backfire. That's never.
Not so far. Okay, so I know we only have a little bit of time left.
Yeah, we just have to talk about Chevron, Loper's right. This is the easy stuff. I'll start, Kate, if that's okay.
Absolutely.
Yeah, Chevron deference, case from 1984. So it was about 40 years old when it was overruled, which we'll talk about shortly. But that doctrine, it was a Supreme Court doctrine, a Supreme Court case that said courts would defer to an agency's reasonable interpretation of an ambiguous statute that was administered by that agency. And so that was called Chevron deference. Many cases, and probably need more manys than that, relied on Chevron deference, though it had been somewhat on its way out in recent years because it had been chipped away at. But it recognized that when Congress's words are not in the statute are not clear, it suggested that Congress would defer. Congress would expect the agency that had specialized knowledge that could consider the policy implications and that could act more quickly, perhaps, than Congress in amending a law or issuing a new law that the agency could exercise its expertise in this area to sort of gap fill and determine what was a reasonable interpretation. I don't know, Kate, if you have anything else to add on that slide, otherwise we could probably,
No, I think we can.
yeah. And so, how does this impact LOIs? And we're going to talk a little bit more about Loper Bright, but I'll just get into, again, the Chevron deference piece. We talked about if the language is ambiguous and the interpretation is reasonable, even if the court thought, well, there's a better read than this. If it was a reasonable interpretation by the agency, the court deferred under the Chevron deference standard. Now, there's something, so that is gone, and we'll talk about what it means, but there is something called our deference. And I made a joke at the ABA meeting, the WASH meeting, about it's not your deference, it's not my deference, it's our deference. Nobody got that. It's a reference to Sports Center from like the early 90s. But I'm making it again because I'm just sticking by it, and Eric gets it. But
Probably everyone is laughing, but
yeah, I know we can't tell. I'm just, everyone, if you could do a thumbs up and just send me a message. So our deference, or Seminole Rock deference, is deference to the agency's interpretations of its own ambiguously written regulations. So it's not statutory language, but it's the regulation. Here we go. People are reacting. I love it. Thank you so much to those folks. And actually, our deference, while there could be some questions about its viability post Loper, we were talking before this about how there may be reasons that it could survive even in the face of Loper. And it was actually relatively recently, in 2019, affirmed by the Supreme Court's Kaiser decision. But note, Justice Kagan said, even as we uphold it, we reinforce its limits. And again, if there's an unreasonable interpretation by the agency, or the language of the reg is not ambiguous, then the court's that's not gonna implicate our deference. So you still have courts serving a gatekeeper function and an interpretive function under our and Kaiser, even if that deference remains. And Kate, I feel like I've talked for those two slides. I don't know if you want to talk about Loper, or if we what we want to do.
Justice Roberts in Loper Bright, in overruling Chevron, says, in the business of statutory interpretation, if it is not the best, it is not permissible. I've heard this man, Scott, colleague, I'm sure he can cite line and verse, like page whatever, Supreme Court cite for that statement.
I think it's 2266, but I haven't said it in a while.
Thank you. So, but it really, honestly, it sums up the whole point of Loper Bright, right?
Yep.
In a word or a few words, Justice Roberts has essentially wiped out 40 years of history under Chevron deference and said, all right, we're the court, three branches of government. Congress writes the laws, the executive branch enforces the laws, we, the judiciary, interpret the laws. In the business of interpreting statutes, i.e. the laws, if it's not the best, it's not permissible. We're not going to defer to an agency, even if they have expertise in this area, because our expertise is interpreting words. That's what statutory interpretation is. So,
and they do tie this to authority, like Congress's directive under the Administrative Procedure Act, right? Is that the courts would interpret the laws. And that's why, for me, if you take out in the business of statutory interpretation and you just drop in regulatory for statutory, I think you can make the same argument that our deference is, may not be long for this world either, based on the current regulatory environment, the sort of approach to administrative authority, and the effort to scope it in, as opposed to let it continue to expand as it has over probably the 40 years since Chevron.
Agreed. The one difference that we've talked about is it's a little harder for a court to say, I know best what these words that you wrote mean, right? It's one thing. It's another thing to say, I know best because this is my job every day to interpret words, what Congress intended by these words. But when the very author of the words is the one interpreting, it's a little hard to say, no, I know better than you what you meant. That would be an argument to support our deference, even with the dismantling of Chevron.
So I think that's right, that our and Chevron are different enough that we could not guarantee today that our is as dead as Chevron is dead.
Right.
But there's just so much hostility by at least the Supreme Court and much of the federal courts today to agency deference, that I think they're looking for every opportunity to at least shrink it, if not wipe it out completely. If I had to bet, I would bet that our does not survive, our or Skidmore or any of these forms of deference to agencies, that they don't survive. Because the issue is not, it's not like the courts are deferring to Congress about ambiguous statutes. The courts are saying,
Mhm.
we are the people who interpret written words in the rule of law. We determine what laws and standards mean, and we are the ones who are expert in that task of interpreting. So get out of the way and let us do our job. I think that is more where these decisions are coming from than it is saying who has more expertise about this particular law or this particular standard. But you're right, our is alive today. So the idea that these letters of interpretation are entitled to a different amount of deference today than before, that hasn't happened yet. Because this is not about statutory interpretation. This is about interpretations of standards and regulations. But we're queuing it up for the situation when these cases are decided in the next few months.
Eric, if I can just say, like, when it comes to Skidmore, I do see that a little bit differently because
Oh,
I think
yeah.
Skidmore just like lets a judge say, "Oh yeah, what you said makes me believe that that's what the words mean." It's the
Right.
power to persuade, which to me, that's just like the
Yeah.
judge can say, "Oh yeah, that was persuasive," because that's how he or she or they wanted to go anyway, right? And so they can say Skidmore, yeah, fine. But yeah, I mean, I think you look back at a certain wing of this court and the importance they've placed on historical interpretation, or what the practice has been, and you could cite Marbury versus Madison to say the same thing that Loper did, right? It's like we interpret the law. That's what the judiciary does, and so I think this court looks to that, even though other stare decisis stuff doesn't seem as important. That farther back historical fundamental view of what the court's role um, is something that they've pointed to.
Meanwhile, as we opine about Marbury versus Madison and stare
Yep.
decisis, one of the chat questions is, could you also remind people the way you get these LOIs? So back to reality, are the LOIs, not only can you get them the way I described with this drop-down menu under standards, under on OSHA's website, but if you go to the regulation itself, and there's like 1910 147, I keep using lockout for some reason, subparagraph E to 1A or whatever, it usually isn't that low that there's a a hyperlink, but like section E of 147 will have a little blue underline, which means there's a hyperlink there. If you click on that, that will bring you to all the interpretations about that sub provision of the standard. So it's an easier way to get to relevant as LOIs, because otherwise, if you're in the whole body of them, you have to do like keyword searches or whatever.
Yeah.
So
And I would suggest if you're researching to try to understand whether there's interpretations and how they apply to your situation, I would look at a level higher. If you do literally 1910 147, that's hyperlinked, and that's going to have every
good point.
interpretation of every sub provision of 1910 147. Because sometimes the
Yeah.
interpretation letter is about a different provision, but it's relevant to the issue that you're researching. So grab all those letters. There may be under 147, there could be 100. It may be a lot, but then you can read the title of it and skip the ones that aren't so relevant. But don't just go to that narrowest provision
Yeah.
that you were cited under or that you were evaluating. Look at the other related provisions and get some useful stuff there.
Okay.
I think we're running low on time and that we are beyond our time. So I'm just going to
Yep.
very, very quickly flag, what's going on today that we think is relevant to letters of interpretation and OSHA guidance. We have a new administration that has come in and has opened the door in a couple of different ways to ease regulatory burden. There was a bunch of executive orders issued on the first day of this administration and a few that followed after that are designed to identify standards, policies, interpretations, and ways that we as employers intersect with OSHA and OSHA compliance to try to make the regulatory landscape more easier to manage. And some of the ways they're doing that is seeking input from stakeholders for standards that ought to be eliminated or modernized. And there was a request for information put out by OMB, the White House's Office of Management and Budget, asking stakeholders to identify standards or other regulatory actions that were illegal, that were complying with them. The cost of complying with them exceeded the benefit, the safety benefit, or any benefit. This was not just an OSHA initiative, but a broad executive agency initiative, or things that were outdated and unnecessary that could be modernized or that could just be eliminated. That process has sort of come and gone. They asked for this information with a very quick turnaround, but it's clear that the door is still open, that this administration wants to hear from industry, from stakeholders about opportunities to improve the way that agencies do business and the way that you are forced to comply with agency mandates. And one of those is a brand new initiative that Scott will talk about because I think he found it on the internet first. And so he's got dibs.
Yeah, I do. I believe I circulated it to our group, the press release. So yeah, on just this month, earlier this month, on June 2nd, DOL announced an opinion letter program, which is meant to provide additional compliance assistance from certain agencies within the department. OSHA is one of those. Wage and Hour, EBSA, VETS, and MSHA are the other four. And if you actually go to the repository for existing guidance on this landing page for the opinion letter program, OSHA's standard interpretation letters are there as well, accessible there as well. So it seems that this may just be an effort to kind of broaden and standardize the policy that OSHA already had, that it'll look like letters of interpretation, just with kind of a uniform name for these key enforcement agencies at the department. And again, you see the highlighted words there, providing official written interpretations from the enforcement agencies, addressing real world questions, promoting clarity, consistency, and transparency. I mean, these are the things that OSHA would tell you the LOI program was already designed to do. So, but as Eric noted, this is another opportunity to interact with this administration on a compliance assistance front, at least in the front, in the first step. As we noted, there could be enforcement ramifications for when you ask for something like this. So even though it's a different website with a potentially different way to ask for one of these opinion letters, I would say it still makes sense to talk through it with someone like Kate, Eric, or myself to assist you through that process. And I might still follow the informal process. I'd say the process that Kate described, to still involve OSHA stakeholders and not just submit an email saying, hey, I have a question, through this new opinion letter program.
Yeah, for sure.
Yeah. Sorry, Eric, go ahead.
No, I was just expressing my agreement.
Yes, and me too, my strong agreement. To me, it's the same exact thing. I don't know whether this is a repackaging
Yeah.
by the new
Yeah,
administration of what we've
right.
always just called LOIs. Now they're called opinion letters, which sounds a little bit more
Yeah,
official, but it
my
seems
guess is that,
more,
it includes these other departments within the Department of Labor, and so they're using sort of a broader umbrella expression for it. But
Yep.
as
yeah,
it relates to OSHA, this is just an invitation for seeking more letters of interpretation, is my interpretation of their
yeah,
interpretation program.
And I'll
yep,
say Wage and Hour issued things like, administrators' interpretations and other kinds of guidance documents that,
Right.
would be signed by whoever was the administrator of Wage and Hour at a given time. So these kinds of guidance documents, these requests for opinions on how, enforcement is going to play out in the field under certain circumstances, agree that it's something other agencies within the department have used. And it could just be a rebrand, to be honest, as opposed to something substantively different.
A rebrand, but even if that were the entire purpose and thought process at DOL, I think we can probably, if I had to bet, I bet that the interpretation or opinion letters that we see over the next few years, to Eric's point about modernization and the government's effort to deregulate, are going to be more employer friendly. So what that means is it is an opportune time to engage in this process where there are gray areas that we've been struggling with, or y'all have been struggling with. But absolutely, I think the other process, even if it ends up, being put in the opinion letter box, first going through the process of engaging with the agency is critical in my view.
And so for the final shameless plug of the day, as we've suggested that we're probably engage us for interpretations that you're seeking, things like that. We have formed a group, the Employers OSHA Modernization Coalition, to avail industry and employers and trade groups of these various windows, of these various opportunities that the second Trump administration has invited input from stakeholders to try to change the regulatory landscape. First, the OMB call for lists of standards and policies and interpretations that should be modernized. That's step one in that process. This new opinion letter initiative is another part of that process. But in general, we are, organizing a group of employers and trade associations to identify those standards, regulations, interpretation letters, enforcement policies, processes, either inspection processes or processes that we engage when we are disputing a citation that could be better, right? We have a lot of experience with this. We know, and we're not trying to make our workplaces less safe. We're trying to make our engagement with OSHA more efficient, more effective, and more reasonable. And there's, clearly the administration wants to hear from us about how they can do that, and then they'll take action, whether that's initiating standard rulemaking processes to change some rules or rescind some rules or issue new interpretation letters or to archive and replace enforcement policies or to rewrite some of their processes for how they do their business. And we are collecting the input of a bunch of really smart and sophisticated employers and trade groups to identify our Christmas list of what do we want to see change? What do we think can be better? What do we think can be modernized? Presenting that to the administration, and then following, I assume, a bunch of different streams, petitioning for rulemakings, submitting requests for letters of interpretation, negotiating, hopefully, the outcome of that beforehand, and pushing the agency to change some of these policies. So we invite you all to participate in that. This is a paid participation fee type of group, but we set the mark I think really low because we think this is a huge opportunity. We think there'll be a lot of people interested in this. So make sure you've got a seat at this table because it's not every administration where where the invitation goes out and that there's going to be a receptive audience. Now is the time. Let's get involved and let's do some work on that regard.
And just, lest I have trouble sleeping tonight, let me just reaffirm, though, that this is not a coalition to burn the bridge down, right? We are not in this to eliminate OSHA or MSHA as agencies or to completely defang them, even, honestly. But it is to deal with things that, as Eric said, we have had years of experience interpreting regulations that in numerous cases are very antiquated. Lotto is a perfect example. It has not caught up with the technological advances of our times, right? So we're still having to comply with the standard that requires like a padlock and a key, which, is just like from I mean, my childhood or whatever, I mean, we have interlocks and Kirk keys and laser beams and all kinds of technology that can be relied on and has been relied on. And by the way, is being relied on very effectively in Europe. And machines are being manufactured in Europe and sent to America that don't even have a place for the lock anymore. So there are a lot of things that can be done that are modernizing and making more effective and more safe or more able to protect our workforces than current standards. So that's what this is about, and streamlining and making things more efficient.
Yeah. And so if you're interested in that, please reach out to any of us, Kate, Scott, or me, or anybody at Maciel Carey. Happy to share more information about, what we've done so far. This is a little bit of our plans for next steps. But we've got a good core group of employers and trade groups already involved in the process. And so right now, their issues are the issues we're focused on. But the more people that get involved and you know what your issues are. You know what would make your life a lot easier. Let's get involved with this group, and we'll make progress on all that. So, thanks everybody for joining us today. I hope you enjoyed this discussion, this format. I found it to be really fun and informative, and we hope you join us for whatever we have next in our OSHA webinar series. It looks like we've got something coming up next month on retaliation and whistleblower actions. We've got some construction topics coming up. Good stuff. So we hope you join us for the rest of this year's webinar series, and you check out our blogs and our special services and all that good stuff. But really, just call us. We love talking about this stuff. We'd love to be a resource for you. So thank you, everybody, and have a great rest of the day.
Thanks, everyone.
Thank you.
Bye bye.